boy, this is the blast.
Well, good morning and happy Workforce Wednesday. Welcome to our WedTalks webinar featuring employment attorney Marc Scheiner to discuss employee handbook updates for 2024, which is just around the corner. I'm Dan Fogarty, director of the Berks County Workforce Development Board. On behalf of my Berks County team up here in the greater Reading area, I am extremely proud of our partnership with Bucks County and our fellow workforce development boards here in Southeast Pennsylvania in creating economic opportunities throughout the region. So speaking of this large, complex, fun region, here's a fun fact about us in Berks County up here in Reading. So first of all, I'm hopeful that we have some Penn State alums on the call today. In addition to the alums, there's probably a few college football fans with us today, but some of you may not know that Penn State and Berks County share a really unique, long, and productive relationship that goes back more than 100 years. Back in 1914, the university first began offering agricultural extension courses to county residents. But that relationship really deepened when Penn State acquired the Wyomissing Technical Institute back in 1958 to establish a campus here in Reading. Today, Penn State Berks includes 30 buildings on 250 acres of land, has 231 highly talented faculty members, and a total enrollment of more than 2,300 students. So Berks County and Penn State are committed to working together to be part of this region's success. With that, I'd like to now turn things over to my friend and colleague, Billy Barnes, Executive Director of the Bucks County Workforce and Economic Development. Billy?
Thanks for the introduction, Dan. A well-drafted employee handbook effectively communicates your organization's policies, standards, and values. Poorly drafted or outdated handbooks create unnecessary risk. Now is the perfect time to revise your handbook before the new year begins. Our speaker today is Marc Scheiner. Marc practices employment law at Duane Morris, counseling clients on a variety of employment issues. He represents clients in employment litigation matters and trains human resources professionals, in-house counsel, and supervisors on a range of workplace topics. He also assists clients in reviewing and drafting employment policies, handbooks, and agreements. Please help me welcome Marc Scheiner. Marc?
All right. Thank you, Dan. Thank you, Billy. Thank you, Andrea. I'm very excited to be here this morning. This is my second WED Talk, and I'm really, it's great to be back. And this is a favorite topic of mine. Maybe you're here because you want some of the updates. Maybe you're here because you like handbook revision and review just as much as I do. Maybe something else. I'm happy to talk about this and dig into this topic. It's a great time to think about updating it. And hey, you know, we still have a month and a few days left before the end of the year. We can try to get this in. And maybe it's something that we're going to tee up, start getting ready to do next year. But there's plenty of reasons why now is a good time to think about it as our calendar year is going to turn soon. So I'll say from the outset, there is not a formal requirement to have an employee handbook. There are plenty of requirements at the same time to post certain postings at your workplace, to have certain policies available to employees. Some companies decide, let's do policies sort of separately and not pull them together in a handbook. At the same time, many find it's good to have it all in one document. It's helpful internally, it's helpful to our employees, it's helpful to our HR team, internal senior managers, lots of reasons why you want to compile this into a handbook. So I'm presuming that we have a handbook, or we want a handbook, or we haven't looked at it in a while, or we want to get a refresh. So my intention today, and it's going to be fast paced because I could easily go for 2-3 hours, but I have a sense we have other things to do, and you know, so we're going to get a quick dose of handbook in the morning. And I want to take this perspective of what's changed, what are some updates that we've seen recently, and what are some thoughts with those things in mind for how we're going to look at our handbooks. What kind of things do you want? I'm looking at this as what kind of things do you want in your handbook? And almost I see these slides as issue spotting a little bit. I'm hoping that these will be useful to take away, look at them, do a little review. Of course, I'm happy to talk further if you have questions. And I'm going to take this perspective of a top 10 list. What are top 10 reasons, or 10 reasons, they might not be ordered exactly in a ranking, but here are 10 reasons I think we should be looking to update our handbooks now or very soon. Let's dig in. Please, I will just also say, we're going to use the chat primarily. I'll pause here and there for questions. I'll try to have a few minutes at the end. But please use the chat, ask any questions that you'd like. I'll try my best to integrate them throughout. And I'll also stick around afterwards to answer any questions that remain. And then you can email me, of course, after today. All right, EEO basics are still essential. Equal employment opportunity is still a thing. Non-discrimination, non-harassment, non-retaliation, other inappropriate behavior. Our equal employment opportunity policy is still essential. Most of us in the HR world certainly know this is kind of the bread and butter. We want to make sure our policy is up to date. Just a couple updates to let you know about. These might not be specifically addressed by name. I don't particularly like to have legal references or summaries of the law or particular statutes in an employee handbook, but just be aware, if you're not already, because it relates to this topic, that we've had some new laws recently. We've had the Pump Act, which went into effect earlier this year, broadening protection for nursing mothers. The PWFA is the Pregnant Workers Fairness Act, which also expanded accommodation requirements for many employers for pregnant employees. This was the case for many states and in many local jurisdictions. Certainly plenty of company policies, separate from any legal requirements, look to accommodate pregnant employees, but the PWFA made this more of a national standard, if you will, across the board for most employers. As a reminder, it's now 3 years ago, but sex, if we think about the word sex under Title VII, this is now inclusive of sexual orientation and gender identity based on a U.S. Supreme Court case from 3 years ago. And you may have heard about Crown Act. The Crown Act is something that is pending and has been raised for a number of years in Congress. Many states, including the Pennsylvania House earlier this year, passed a state version of the Crown Act. And this is prohibiting discrimination on the basis of hair color and texture, typically associated with race or ethnicity, national origin. So just some updates and some things on the horizon to think about. I'm not going to get into, I could talk for at least half an hour or more about this alone, about some key parts of your EEO policy. I think this, I'm hoping this is a little bit of a checklist. Maybe not entirely inclusive, but some key parts. We want to have a basic statement of non-discrimination, including the various protected groups under state and local laws. And if you're multi-jurisdictional, we'll talk about this later, you want to think about how to approach possible different protections in different states in which you operate. Harassment, you want to define unlawful harassment, sexual harassment, and other harassment. I still see handbooks that focus on sexual harassment exclusively. Important, no question, but we also want to think about other kinds of harassment as well. I like providing examples. I like to be able to pull out an EEO policy from a handbook if I am an employee and be able to know what's there. What are we talking about? Give me some examples, flush this out a little bit. Of course, this is a little bit of a side note, we need trainings. And I have a note at the bottom of this slide, we need to train our employees on harassment prevention. What's okay and what's not okay in the workplace. Especially our managers, they're the ones that of course need to know that material for themselves, what's okay, what's not okay, but they're often the ones who are having complaints raised to them. They need to know how to handle complaints, how to recognize those complaints, what to do with those complaints. I hope we're all aware that an employee complaining to a manager about potential discrimination or harassment or retaliation is telling the whole company, telling the whole organization. So if our manager does not let you in HR know, or whoever the point person is to handle these kinds of concerns, if that person is not alerted by our managers of the issue so that we can investigate as an organization, then we're not fulfilling our legal obligations. So training managers on how to handle this is absolutely essential. We want to talk about retaliation specifically. I'll say more about that in a moment. We want to make sure that it's clear our policy applies to applicants as well. as far as how we're hiring, how we're recruiting, if people need reasonable accommodations to engage in the hiring process. Also, people who don't work at our organizations, who interact with our employees as part of our employees' jobs, our employees are also protected. So we can't have a customer, a vendor, a supplier act inappropriately towards our employee. Our employees are protected. All forms of communication, off-duty conduct is captured as well. I think putting reasonable accommodations into your EEO policy makes sense. I'll say more about that in a moment. You want to have a complaint procedure, multiple points of contact, not just a manager, not just HR. How about both? Maybe referencing also another manager. Employees could go to other managers. It doesn't just have to be their own manager to raise these kinds of issues. Maybe you want to have a senior manager point person. Maybe you have a hotline or an ethics complaint system that's managed outside of your company. Many organizations more and more are having those types of things. So complaints can even be raised anonymously. Give various options and also talk about the sanctions for a violation. These are serious issues, a serious policy with serious ramifications. All right. It's so exciting and fast paced. We got to keep going. Number 9, retaliation claims continue to increase. I just mentioned I would say more about retaliation. Well, here I go. I've seen as recently as this fall, it was I guess September, October, a client who asked me to review a handbook, hadn't been looked over in a couple of years, still no specific mention of retaliation. There was in another handbook I saw earlier this year, the mention of the word retaliation appeared one time just to sort of capture that it wasn't allowed, but there was no examples of what retaliation meant, what it covered. Retaliation claims are the #1 type of claim that are included in EEOC charges. Last year, 52% of charges filed with the EEOC included a claim of retaliation. And since 2018, more than half of EEOC charges have included retaliation claims. That's a lot, right? So to not specifically capture and cover in your EEO policy a separate provision on the #1 type of claim that gets raised to the EEOC, I think is a big miss. And I still see it happening. Due to the nature, I'm not going to dig into what a retaliation claim means and what it looks like and how it's proven. I'm either going to assume that knowledge or we could talk about it separately offline. But these complaints, by their nature, are tougher to kick on summary judgment. Just sometimes the temporal proximity alone to when someone raised a complaint and when an adverse employment action happened is enough to get past summary judgment. Is enough to not be able to get rid of these cases sometimes so quickly. And even if the complaint that somebody raised didn't pan out, was not substantiated, had no merit, that person who raised the complaint is still protected from retaliation. Retaliation protections are really broad, and over the last 10 years or so have only gotten broader. So really a serious area that, quite frankly, is not, as I've said, in the handbook and also sometimes in practice, not always looked at the same as discrimination and harassment. So I suggest a separate policy or separate section in your EEO policy capturing this. And who it captures is not just the people that complain, people who are witnesses, people who are participating in an investigation to look into an issue. If I have a close relative who's also working at the company, you can't retaliate kind of for something that I did by getting back at them. Those people are also protected. And the protections, as I said, are broad. Anything that effectively, my way of boiling this down, is anything that effectively gives the message to the employee who complained, you shouldn't have done that, or says to other people, because everybody else knows about this as well, don't complain, potentially retaliation. So not always firings or demotions or pay decreases, changing somebody's workstation, changing their job responsibilities, taking them off of a project that was deemed to be a good project to be on. All those are potential areas for retaliation claims. Check your handbook is what I'll say here. Okay. Disability accommodations. If you have not been dealing with disability accommodations or the interactive process very much, part of me wants to say, good for you. You got a little lucky. Also, I might want to say in a more snarky way, well, I hope you're not missing something. Or it's going to happen soon enough, because these topics, these issues are popping up way, way more. This area of disability discrimination, particularly relating to reasonable accommodations, it's the second highest after retaliation as far as the number of claims. And that's been the case for the last few years. And more and more, we're not going to go through the ADA, the Americans with Disabilities Act today, we could spend a whole hour talking about that, and maybe I'll come back next year and do that if you want. But the ADA and the interactive process, reasonable accommodations, really, really key. Many of us I know on this call work at small organizations where we don't have the FMLA to worry about because we're under 50 employees. All right, that makes it easy. But we still have the ADA. If somebody has something, a medical condition, a disability, something that quite frankly could be deemed a disability, and the way the ADA now looks at disability is a really broad coverage and protection. Sometimes people that might not even think that they have disabilities would be deemed under the ADA to have one. And we need to think about how to handle these issues. We need to make sure our managers, again, are trained on how to recognize a request for an accommodation, how to come to HR if they're concerned about somebody's ability physically or psychologically to do the job. We need to know as HR or senior managers what the interactive process is, what our legal obligations are, and trying to figure out whether we can accommodate an employee who says they need some kind of accommodation to do their job. Again, we could dig into this in more detail, but for the meantime, from a handbook perspective, this needs to be included. This is a really key area. Now, I'm focusing here on disability accommodations because that's where I'm seeing the most number of cases and issues. But when we think about accommodations for our handbook, we also want to include pregnancy, and we also want to include religion. So it's disability, pregnancy, and religion are the three areas that we need to think about potential accommodations. Pregnancy, I mentioned a moment ago, or in number 10, as far as reasons, with the PWFA, we're making sure that we know, and we're stating in our handbook, that employees who are pregnant and need accommodations due to pregnancy, even if they're not disabled, are still available to have an accommodation. In response to a question, 15 is the threshold number of employees for the ADA to be applicable, but state laws often have lower thresholds. Here in Pennsylvania, the PHRA has a threshold of 4. So even if the ADA is not applicable, the PHRA would be if you have at least 4 employees. And the PHRA has a very similar analysis to the ADA and effectively similar requirements as far as needing to reasonably accommodate. Think about whether we can do that through the interactive process. I think we should, going back to the handbook, again, I could dig into the ADA way too much, and we all should. In the handbook, I suggest putting an accommodation policy about accommodations for disability in particular in 2 places. One in your EEO policy, and you could include religion and pregnancy there as well. And also in your leave policy, in your leave or your leave section of your handbook. If you have the FMLA, if that's applicable, you want to make clear that if people need additional leave time in an unpaid way because they've exhausted their FMLA or they're not eligible for FMLA, there's still the ADA to possibly give them leave as a reasonable accommodation. When folks need leaves, even if there's not FMLA that's applicable, we still need to consider the ADA if it's for their own disability, medical condition. So the ADA picks up where the FMLA leaves off. So if you've ignored the ADA and the interactive process or the PHRA, these issues, it's time to think about these for the new year. Okay. Lunch breaks, overtime, deductions, oh my. We could go into wage issues again. I mean, every topic I'm mentioning, I feel like could be, at least an hour conversation. Wage issues could be sort of all day. Let's just say a few things about some areas here. Employee classification, still important. Define in your handbook what it means to be exempt, what it means to be non-exempt. For purposes in the handbook, it's enough to say that if you're a non-exempt employee, you're eligible for overtime. And you need to be tracking, and you'll be paid for all time worked. How you track time in your organization is going to be different than another organization. So these are very particular policies. But you want to think about in your handbook how you are telling employees, non-exempt employees, how to track the time. Are we doing it electronically? Are we doing it with a time clock? Are we doing it with paper documents? How are we doing this? Most importantly, we want to make it clear that non-exempt employees and their managers need to be recording time accurately, and the managers need to be aware of when people are deviating from their schedules. We need to pay our non-exempt employees for all their time worked. If somebody's working an 8 to 4 schedule as their regular hours, but they send their manager an email after 4 o'clock, that manager knows they're working. And if they get a timesheet from that day that effectively says 8, or if the timesheets every single week are 8, 8, 8, 8, 8, or 7.5 times 5, whatever the numbers are, that's increasingly deemed a likely inaccurate document. I don't do a lot of wage litigation, but my colleagues that do see this all the time, where we have timesheets that are basically saying 7.5 straight through, week after week after week. That's just not accurate. People are not actually working the same exact number of hours each day, week in, week out. And when that's 7.4, all right, we don't care from the perspective of a piece of litigation. But when that's 7.6 or 7.7, and it varies, we're not paying people properly. And if they're keeping better records than we are, that's where wage collective class actions come from, and that's where these huge settlements come from. Again, we could say a lot more about this. I want to just alert you to the issues that's out there. We're seeing a really big increase in this area. Comp time, I'm just mentioning this. I still see this, and quite frankly, I see it at smaller organizations. And I think I know we have a number of them here. I know we have a number of them here. You can adjust people's schedules. You worked late one day, as long as it's not impacting overtime calculation and different work weeks, I could tell you to come in at a different schedule to sort of balance the hours out or the compensation out. But I can't just give you time off instead of paying you. And that might not mean what we mean by comp time, but sometimes comp time is looked at as you're giving people time off in lieu of paying them for their hours worked. We have to pay for their hours worked. Comp time is a red flag. Even if it's not done in an inappropriate way in practice, it's going to be something that's going to get DOL attention if you have an audit that gets on your doorstep. We also need to think about meal breaks. If we have people that are not taking their full breaks and we're auto-deducting that time, that's a problem. If people are supposed to take a half an hour and do a little bit of work, answer a phone call, answer some questions, they didn't have a full period of lunch break, 30 minutes, they haven't had time off sufficient to not pay them. They have to be paid for that time. We want to capture these issues in our handbook in some concise way. We don't have to go through all the permutations, but people need to know to keep track of their time. And if they work through lunch, if they don't take a lunch, if they work before their scheduled hours, after their scheduled hours, they need to let their manager know or record their time properly, however you record your time, so that they can be paid accurately. And I suggest having a complaint procedure in your handbook as well, so people know how to raise complaints about pay issues. For our exempt employees, we want to include in our handbook, absolutely, the DOL safe harbor policy. That basically says our exempt employees are paid on a salary basis, week in and week out, the same amount, regardless of hours worked. And we are not going to take deductions from their pay inconsistent with the salary basis. There are some very limited exceptions that basically apply to, okay, if somebody is taking a PTO day, you know, that's captured and that's effectively making them whole for that week. The FMLA has some distinctions that allow for less than full week deductions. But generally speaking, the rule of thumb, the default, is that an exempt employee is getting paid their full regular salary for any week in which they do any work for the company. And generally speaking, again, as a default, we can't be taking partial day absences or even full day absences from exempt employees, with just some limited exceptions. I'm going to leave it at that for now on this issue, but this is a critical point. It's more of one of the legal policies that aren't fun, but we want to make sure that we capture this. We also want to say, I'll say one more thing about this. Again, having a complaint procedure for our exempt employees, and as part of this policy, making it clear that if we discover there's been an error, we will correct it, and we'll make a good faith effort to make sure anybody else impacted by a similar improper deduction is also made whole, and we'll correct it going forward. If you don't have this language, these points captured in a policy, the DOL has an increased chance of seeking penalties and damages for taking inappropriate deductions. But if you have the policy, people know how to raise a concern, and you look into a concern and you correct it in a timely manner, you are better able to deal with those penalties or not have them assessed. If people run out of PTO, a question that was asked, and they take that day off anyway, do we have to pay them for that day? Generally speaking, yes. So if I don't have any PTO or leave time available and I'm an exempt employee and I take a day off, the default rule is just that. I get paid for my whole work week. Technically, I show up on Monday morning, I do a little bit of work, I get sick, I'm out for the rest of the week. There's no PTO policy in place, or I've exhausted all my PTO. The default would be I'm paid the whole week. Now, there are some potential exceptions based on state or local paid sick leave laws, depending on the nature of your PTO policy or your sick time policy. There may be ways to take partial pay for that week, but it's going to be in full day increments only. But you need to have that specifically listed in your policy and look at that more clearly. But the default rule is paid for the full week. And I'm going to move on from, I see another question. What if an employee is contacted during a PTO day for job-related questions? They're working that day. And again, there might be some distinction depending on the nature of the PTO. If it's not FMLA, if it's just a PTO day, they're pretty much working that day. That PTO might come out of a bank, but they're getting paid for that week anyway, generally speaking. We could deal with the ins and outs of that, but the default is paid for the full week. If you have a certain plan or policy in place, you might be able to take out full day deductions, but not partial day deductions, unless you're dealing with the FMLA. It gets technical a little bit there, but it's a really tricky area and an important area. Let's talk about the NLRA, the National Labor Relations Act. Still, I hear plenty of employers say, oh, that's the union law. We're not unionized. Okay, great. But it still applies to you. The NLRA applies to most private sector employers, regardless of whether or not they have a union. So often this is viewed from the perspective of, oh, we don't really want to have a union in our workplace, or we're dealing with an election, or we're bargaining with a union and there's a collective bargaining agreement in place. Okay, we might know these issues better in light of that, but as some background, employees have the right to discuss the terms and conditions of their employment. I gave a little bit of background more on this slide, but coming from the language of the NLRA, employees have the right to talk about their jobs. Employees have the right to vehemently and adamantly discuss their jobs. This could get heated. This could involve discussions on social media. This could get really close to potential violations of other policies. I think about our EEO policy, and there's some tricky areas to navigate here. And to make it even trickier, the Labor Board is going back and forth over the years about what's deemed to be an okay rule, what's deemed to not be an okay rule. In the current moment, due to changes in the board makeup, due to some recent board cases, the current view of the board is that for workplace rules, if there's a reasonable tendency, of course, what that means is not always clear, right? But if there's a reasonable tendency to chill employees from exercising their Section 7 rights, which is basically, we'll say for our purposes right now, talking about terms and conditions of employment or potentially engaging in union activity, then it would be an impermissible workplace rule. So we have our EEO policy. Our employees are not permitted to engage in harassing conduct towards each other. That's a protection from our EEO policy. Absolutely. At the same time, the board would say, yeah, but we can't have a policy that says, be respectful to all of your coworkers. Now, I think many of us would say it's a good thing that our employees are asked to be respectful. They should be respectful of each other. Totally agree. But to say, be respectful to your coworkers would be an example that the board would say, that might chill employee Section 7 rights. Being respectful might not include me voicing my concerns about my conditions of employment, me voicing my view that we should have a union in our workplace. That might not be respectful. I might get into an argument about that even. The board would say the idea of respect like that in a wholesale manner, that's a problem. Customers, clients could be different. So for a while, this is not a new thing, actually. This is going back a number of years. Respect is a problem, right? It was kind of weird to say respect is a problem in your handbook, right? Asking employees to be respectful to each other that's likely to go too far. The word I kind of like is cooperation. Cooperation works better. I think it's getting at the same point, but respect seems to be a yellow flag. Here for a to-do item, and this is trickier, in part because it's not clear all the time, in part because it's changing. But we want to reconsider workplace rules based on the current board cases. And I'm giving a couple of examples here. These are coming directly from the board's general counsel and a memo that was put out some years ago. And this is a combination of an older memo and where the board thinking currently seems to be based on recent cases. And coming together, my colleagues who focus on labor work think that this is where we're heading. And these are examples pulled directly from this memo of examples that the board would say, the general counsel would say are unlawful. So if something is not public information, you must not share it. That gets really close to a confidentiality policy that we might have in place. You absolutely have the right to protect your company's confidential information and to prohibit employees from sharing it or sharing it in a way that's not approved. But what's not public information is also people's wages and salaries. And if I think that there are pay issues, if I think we're not getting paid to market, and that if we had a union in the workplace, we would do a better job of getting the pay that we deserve, coworkers, I'm writing to you all on social media or saying something, that bit of salary information is not public information, but it's also protected information from the NLRA's perspective. Employees have the right to talk about, to share their terms and conditions of employment, including their compensation. And so if somebody gets access to that information, they're able to share that. We can't restrict that, generally speaking. So not sharing public information in this example, this quote from a policy, would be seen as too broad from the NLRB's perspective. Causing damage to the company's business or reputation. You can't destroy company property. That's reasonable. But when we say something like the company's business or reputation, arguing about terms and conditions of employment again. I mean, I just think about a post on social media where somebody is saying, I hate working for this company, the managers do this, I'm not paid properly, gives a whole bunch of things. That might not be something that you want to have out there, but that's essentially protected activity. We could talk about how you might deal with that, but essentially it's protected activity. And this is another example in this second bullet point of language that goes too far from the board's perspective. The last one, I'll just make a mention of walking off the job. You know, to the extent that that might seem to indicate a labor strike or some kind of walkout from a labor perspective, that's why that one goes too far. So lots of things that are happening in this area and changing, and this is a little bit more nuanced as far as changes that might need to be made into your employee handbook. Wow, we've covered a lot in a pretty quick period of time. I see some PTO questions. There might be something I didn't answer yet. I will get to them later on, but keep asking questions in the chat. We'll keep going. Let's get into the weeds a little bit more. My little witty heading here for marijuana and other drugs. If you haven't heard, marijuana laws have been changing for a number of years on the state level. More than 3/4 of states, 38 states by my last count, have some kind of medical marijuana law in place. There's different versions throughout the country. Some are more protective than others, but most states have some kind of medical marijuana allowance. And increasingly, we have states that have recreational marijuana use permitted as well. Of course, at the same time, from a federal law perspective, marijuana is still, of all kinds, is still a Schedule I substance and absolutely prohibited. And so we often have the tension between federal law and state law. And when we have state laws that say to employers, you cannot take an adverse employment action, including not hiring somebody, including firing somebody, solely because they are a medical marijuana user. Now, some states go further with recreational marijuana, but generally speaking, we're dealing with medical marijuana issues. This really rubs up some issues about disability. So we can't say you, whether you have a disability or not, are a medical marijuana user, and therefore we're not hiring you. That would be improper in many states that have these kinds of protections, at least from a state law perspective. From a federal law perspective, permissible. So how do you deal with that tension? How do you deal with that? And it's really tricky. I wish I could be a better messenger on this one. We need to consider some federal regulations. Maybe we're covered by DOT, Department of Transportation guidelines because of the nature of the work that some of our employees do. That would fall under different regulations and likely be something that we would look to say, well, we have to meet certain higher standards because of the nature of our work here. Or maybe we are an organization that works with children or the elderly. Might be different standards at a state and federal level along those lines to consider. These are areas that are tricky and are having companies ask questions about, do we want to test for marijuana at the time of hire, later on in the process? Do we want to get out of marijuana testing completely? I've had a number of clients say to me just that. You know what? We still want to do drug testing. We still think that's appropriate and the right thing to do for our business, our industry, the kind of work that we're doing. But let's not deal with all the marijuana changes. It's just too much. And I see a lot of companies who operate in different states in particular coming to that conclusion. We have different state laws to deal with. I have 8 different permutations about whether or not to test for marijuana or how to handle it. Gets really tricky. That's not to say that in the nature of your work, you don't want to test for this or you want to have a strict drug policy. I work with some clients in the construction industry. We're around heavy equipment a lot. We're in dangerous work sites dealing with big machinery or hazardous materials. We want everybody to be as attentive and focused and capable of doing their jobs as possible. And we want to have strict drug and alcohol testing and prohibitions and testing. Okay, but we still need to consider some state law issues. We need to think about how we're going about it. I will just make a note here. If you're in an organization, in an industry, here's a place where you want to designate safety sensitive positions. This is going a little bit beyond the handbook, but just because it might get pulled in. If we have safety sensitive positions, we have a better chance to test for and make employment decisions around, in this case, marijuana use, because you're not making a decision solely on somebody's authorized use of recreational marijuana. You're also considering the nature of their job. So somebody, let's say, is working in the office, different standard perhaps than somebody who is working in a nuclear power plant facility on high ladders and, you know, really dangerous situations. Could be seen as different there. As a reminder, and if we are putting together or we have in our handbook a substance abuse policy, drug and alcohol testing, if we're doing it, to the extent that we're doing it, can only be done after a conditional offer of employment. So you can't do the test and then decide whether or not to hire somebody. You give somebody an offer of employment conditioned upon successfully completing the drug and alcohol test. It's at that point that you get their consent to do the testing and you do it then. We have to always consider state law limitations. I'm going to say something about state laws soon enough, but throughout all this, we need to consider state law issues. A lot of this focus so far has been from a federal law perspective. We got into state law with the question about the ADA and thresholds, but our states have similar non-discrimination provisions, have similar disability accommodation provisions and laws and regulations. And here too, states have particular things to say about drug and alcohol testing. In some states, New Jersey is close by. New Jersey generally does not permit random drug testing. Pennsylvania, that's generally permissible. And so we have to consider, if we're in different locations or we are operating in different states, what we could do. And we want to make sure if we are going to do drug testing that we have a policy that's strong and that also lays out the testing procedures. And from my perspective, you can get a copy of the slide deck. You'll either get it from Bucks County team or you can email me afterwards and I can get you a copy of the slide deck. Key aspects of a substance abuse policy, regardless of how you deal with marijuana, we want to have clear prohibitions on what's not allowed, generally the use, the sale, possession at work. Employees, even in medical marijuana situations, are not permitted to use medical marijuana at work. No state court, the Colorado Supreme Court most notably said very clearly no. It's very clear across the board. Use of marijuana or any drugs during work, not permitted. Same thing about impairment. Employees cannot show up or become impaired at work or during the workday. We can require that people be fit for duty, that they're in a condition able to do their jobs. And I think even if we don't have drug testing set up, it's good to reserve the right to test for drugs and alcohol consistent with applicable law. You often don't need to test, quite frankly. If somebody has a workplace disruption issue, if somebody, does something inappropriate at work, you don't have to figure out if they're under the influence of drugs. You could deal with and discipline on the basis of the conduct at issue. Testing procedures should be outlined if you are going to do testing. If people are using prescriptions or over-the-counter medications, having a procedure where people can report a potential inability to do their job. I'm on a pretty good prescription allergy medication. Makes me kind of drowsy at times. It's hay fever season. I'm taking a little bit more of it. That could impact people more, quite frankly, than pre-bedtime low dose of medical marijuana. And so where are we putting that effort? On the Benadryl or on the marijuana? And I'm not making a policy statement there or any kind of judgment. I'm just saying a lot of illegal drugs are impacting people just as much. To Patty's point, marijuana, as far as we know, I'm not a doctor, stays in our systems for a long period of time. And it's not there's not a great way, as far as I'm told, from what I've looked into, to have testing right now help us determine when the use occurred. It might be that the increased amount in someone's system indicates more recent use, but not necessarily. And we, of course, all metabolize different substances differently. Also, I think having a provision in your policy about self-identification. Somebody needs maybe time off to deal with a drug addiction issue or an alcohol addiction issue. Many of those addiction issues are disabilities, and we might need to accommodate them as a separate issue. We're back into the accommodation area, but having some ability to self-identify. Maybe this is also where you have an employee assistance program, an EAP. You might want to refer to it here. If people have drug or alcohol abuse addiction issues, confidentially and outside the company, there are people to talk to. And of course, sanctions for violating the policy. I see a few more questions popping up, but I might need to leave them for the end because I want to make sure I get through the slides. All right, let's get out of the weeds and talk very quickly about our often updating benefits sections. Some organizations still like including information about benefits in the handbook. I think more and more what I'm seeing and generally recommending is not to give a lot of detail in the handbook. Maybe you list the benefits that people may be eligible for. Maybe talk about, for instance, eligibility. You have to work, you have to be regularly scheduled for 32, 35, whatever number of hours based on your insurance carrier policy to be eligible for group healthcare benefits. Okay, maybe you state something about eligibility or dependent eligibility. But I think just a listing of benefits or some basic information is all you need, because these are things that get updated at least annually. And I'm not saying you shouldn't look at your handbook annually. I think an annual review of your handbook is a good thing, but just to update the amount of premium or the percentage that the company is going to pay, or how much the FSA, HSA deduction from your paycheck maximum has changed. Those are silly tweaks that don't need to be captured in your handbook. Better, I think, to put it in a separate benefits document and hand out. But I would make sure you state that the plan documents of our group benefits control how those policies are going to be affected as far as eligibility, limitations, restrictions, any summary that you put, even if it's a robust summary of the benefit in your handbook, that's not controlling the outcome. Nothing in your handbook is controlling how the benefits apply. The plan documents control. You want to state that directly. I'll call it a benefits disclaimer. That's the main thing I would want to have you have in your handbook. All right, let's talk about PTO and leave policies. We've mentioned this a few times throughout. It's just scattered throughout the conversation. It's just there. I sort of quip that this is a section that your employees know very well. How do I get time off? How do I request the PTO? How do I deal with these things? This is what employees know pretty well. So you have a lot of flexibility. And here in Pennsylvania, just like many states, you have nearly free range to do what you want here. But you have to be consistent in how you're treating people. And you have to follow the policy once established. So if you have lots of rules, this is an area sometimes where you look at handbook that hasn't been updated in 3 years, let's say, and you realize, oh, that's not what we're doing right now. But in the area of PTO, it gets really tricky because very closely associated with PTO is wages. And are we paying people properly? Are we following our PTO policy? We don't have to provide PTO, but if we provide it, we have to follow our policy. All right, so first on the area of leave, I mentioned this a little bit in passing, looking at the FMLA and ADA and the accommodation area. If the FMLA applies, okay, let's make sure we have an updated FMLA policy. In particular, military reasons for taking FMLA and intersections with state laws, as well as our own company leave and PTO policies. How do those play into things? We could say more about that, but the FMLA conversation could be another half an hour. If we don't have the FMLA applicable because we're a smaller company, under 50 employees, then we have lots of flexibility. And you might not have any additional leave policies, but many companies still want to have some kind of family or medical leave policy. Maybe it's a parental leave policy, and it could be unpaid. The FMLA is unpaid. One thing to be aware of here, again, is some state law issues with disparate treatment. Maternity leave, where only employees who are women and have given birth are eligible for leave, is seen more and more as a problem based on gender disparity. Only women getting leave. Parental leave is capturing more. Now, you could give more time off to an employee who has gone through childbirth. That childbirth is one thing, but you can't sort of say just for women or just maternity versus paternity leave. I've seen policies that say paternity leave for 4 weeks, maternity leave for 8 weeks. That's increasingly a problem. So we want to be aware of those disparate treatments, and some state laws have particular things to say along those lines. For PTO, again, lots of flexibility. Is it one bucket of PTO? Use it for any purpose: vacation, sick time, school issues with your child. Or are we going to have different buckets? Here's your vacation bucket. Here's the bucket for being sick or dealing with, issues about sick kids or whatnot. Here's personal time. Here's floating holidays. You could do what you want here, but think about what you've done or what you want to do. Many companies, I'm finding, increasingly prefer the one bucket approach, especially when we're dealing with paid sick leaves under state or local laws, because then you're more easily able to use that big bucket of PTO and say, I'll say Philadelphia. I'm in Philadelphia right now. The Philadelphia paid sick leave can be used by employees who are eligible for PTO using their already established PTO bucket bank. We're not giving additional time. So if you have a state or local paid sick leave law, you generally could do the same thing by using your full bucket of PTO to capture the use of the paid sick leave. There's definitely issues to deal with there, and there's lots of permutations and things to look at. It gets tricky, especially for people who are not eligible for PTO. You have to make sure the accrual rates are in certain ways, etc. But as a general matter, that's a way of dealing with it. As far as accrual, are people accruing PTO over a period of time, every pay period, for instance, or every month, every quarter? Or is it allotted? Every quarter you get this much, or at the start of the year you get this much. Is it a calendar year? Is it a fiscal year? Again, lots of flexibility, but lots of potential details that employees are going to A, know, and B, I don't want to sound cynical here, but they'll try to find the loopholes. Or you haven't just considered a loophole and it'll come up. Advancing time, carryover. Can you carry over PTO from one year to the next? Some states say you have to allow that. Some states say if you don't allow it, you have to pay out for it. You can't actually have any forfeiture of the PTO. Many states say do what you want, and that you can at some point forfeit and have PTO loss. That's a tricky thing, and you definitely want to check with your state laws if you want to have any kind of forfeiture of PTO. Increasingly, states are saying that's not permitted. And payout upon termination. About a dozen states require that PTO be paid out upon termination. Pennsylvania is not one of them, but be aware if you're in different locations, that could be an issue. Woo! And speaking about states here and there, those tricky state laws. I mean, this is something that gets mentioned lots of times in a handbook. If you don't have in your handbook the phrase in accordance with applicable state law, or consistent with applicable state law, or to the extent permitted by applicable law, whether you say state, federal, if you don't have that popping up a bunch of times in your handbook, I'm not saying something's wrong, but I think it's good to check why not. Lots of statements we make in our handbook are valid statements, but they might need to be limited in some way. And having that reference to applicable law or consistent with law, recognizes and says to especially the EEOC or the DOL or as part of a piece of litigation that you're aware of the restrictions or limitations. So how are we handling issues if we're in multiple states? Do we have one handbook? Do we have multiple handbooks? Most commonly, I like to have one main handbook and then provide to employees the relevant addenda that they need. You work in Texas for a company based in Pennsylvania. Great, here's our main handbook. It's Pennsylvania compliant. Here's an addendum with separate provisions and policies applicable to those people generally working in Texas. That's, I think, the approach that I would most recommend. There's different permutations that we could talk about if you want to talk about. That's the standard approach that I think works the best, where people are getting the information that they need, but we have one standard main handbook, so you're not constantly updating multiple policies. States have lots of things to say about leaves. Paid sick leaves, I mentioned a moment ago, are a really key and sometimes tricky area. Disability issues, pregnancy accommodations. About a dozen states have a state family and medical leave that needs to be considered. Many states have variations of military leave that needs to be considered. Voting leave, jury duty, emergency responder, the list goes on and on. It might be dependent on how many employees you have. Some states say the total number of employees is what matters. Some states say it's based on the number of employees working in that particular state. And some states say if you only have one employee working in this state, this law applies. And this law may be giving paid time off to that employee. So if you have a random employee that's working remotely in Arizona for the company, and that employee says, hey, I want some additional paid time off under the state paid sick leave law that you're not aware of, well, you have to look into it at that point. But those are obligations that you may have to those employees. And so we can't ignore even the remote employees working randomly in many cases. All right, it's a little scary, right? Wages, states have lots of things to say about wages, how we're classifying employees, different exemptions that might be applicable beyond what the FLSA provides. Of course, minimum wage varies across the states. Pennsylvania is still consistent with federal minimum wage, which is still $7.25, but some states are well above $15 now. Overtime calculations, generally we're talking about time and a half for hours worked over 40 hours in a given work week. Some states, Colorado, Nevada, California, most notably, also have daily overtime. So even if I'm not working 40 hours in a work week, if I'm working more than 8 hours in a day, I might be able to get overtime in some states. So that's a state law issue as well. I already mentioned issues about carryover, forfeiture of PTO, payout upon termination, timing of final paychecks. States have lots of things to say about those areas. So you want to check with your state law. In Pennsylvania, we have lots of flexibility in these areas. We don't have to pay out upon termination of any accrued PTO, and timing of paychecks is reasonable, basically based on your next pay period generally. All right, I'm going to start winding down this exciting hour. We're not done yet, and I'll take some questions too. But I also want to leave with a reason to update the employee handbook that you have with the view of a handbook not just being a document that you share or something to check off your list or put out at orientation. I think it's also a statement of company values. Have we expanded our EEO policy, for instance, to include specifically listing protected groups instead of just doing a catch-all that says, all other protected groups covered by applicable law? Have we thought about including statements about diversity or inclusion? And again, this is not a conversation on DEI areas, but if that's important to our organization, let's include that. Maybe we want to think about the tone we take or the approach we take. We can make this more legal. We can make it more fun, dare I say. Maybe you want graphics. Maybe you want Q&A throughout the handbook. Again, the tone and approach is up to you. The amount of detail you provide. If you want to have lots of internal policies that I might say are more business policies, expense reimbursements or how you deal with travel issues. If you want to pull that in because this is like our handbook of all of our policies, and this is everybody can go to this and get most of their information, that's fine. And maybe you just want a slimmed down version to give to people about the basic employment policies, that's fine too. I think it's just worth giving some thought. Maybe it's about your industry expectations or how much turnover you have, or maybe you're having different versions of your handbook for your exempt folks, your non-exempt folks, your sales team, your office team. All those things are possible. I think it's just a way of looking at the handbook from this perspective as well. We want to educate our employees on what's in the handbook, typically done in an orientation type period. If you make significant changes to them, you might have obligations that you might want from an employee relations perspective to update employees on the changes that have been made. You need to train managers. Managers are your so-called front lines in implementing, enforcing, having questions asked to them about the handbook. They need to know what's in it and train them on it. I view the employee handbook that you have or don't have or need to revise, or maybe it's in good shape, whatever state it's in or status it's in, I see it as a living document. Too often, this is something that does get pushed aside or doesn't get updated, or gets updated and then doesn't get published and sent out to people. And I think the fear sometimes is, what if it's not fully accurate? I want to make sure everything's exactly right. Yeah, of course, do that. But it's going to change. It's going to get updated. We could probably have this conversation again next year. I'll make similar points, but there'll be some changes, some other things that we might want to discuss. And I guess before I take a few last questions, I'll give you a bonus reason. And I said this word a moment ago, and I think I maybe said at the beginning, or maybe I just was talking about my excitement on this topic. And this was fast paced. This was a lot of information. I appreciate that. You'll get the slides, or I'll give you the slides. I think handbooks can be fun. All right, maybe I can't convince you of that, but I think they're more and more expected, or usually expected. I think at least some sections are read by your employees, or at least when they have an issue pop up, they're read, especially PTO, especially leaves, and some wage issues for sure. I think they can affect litigation outcomes. You know, if you don't have a policy that talks about how people are getting paid or what the limitations are on payout upon termination, and you go in a direction inconsistent with what's in your handbook, then that's a problem. I don't think they have to be overwhelming. We could look at the policies, we could divide it up, we could make it work. And as I just said a moment ago, employment law will continue to change. So do the best you can, pull it together. I'm not kind of stuffing that off after an hour of talking about this, being like, oh, whatever, just get it out there. You don't want a handbook out that's not updated with legal requirements, or that's not consistent with your policies and practices. But once you have it done, get it out there. You can revise it again. And even if you do the very best job you could possibly do, something in employment law is going to change. All right. So I'll leave it at that for sort of my main, comments, or really that's the presentation. But I want to look at the side chat and see if I have some things here. Have I ever seen handbooks set up as a PowerPoint presentation? I've seen that as part of orientation and training. I have not necessarily seen that as like, that is our employee handbook. But the nature of the document is really not that important. If people could access it, that's really what it's about. So I haven't seen it set up that way, but I don't see a particularly potential problem with it. How many pages should a handbook be? What is considered too much? This is the best answer is, it depends. I've seen perfectly fine handbooks that are 20 pages. I've seen perfectly fine handbooks that are 120 pages. I've seen terrible handbooks that are all sort of pages. I wouldn't be so focused on the number of pages. Again, that might be a little bit about your style, your approach, but I wouldn't be focused too much on the number of pages. I think if you are under 40 pages, it's just pretty small handbook, pretty straightforward handbook. Unless you have small fonts, or unless you really just want to cover the basics. I think once you're over 100, I might want to know why. But again, maybe it's in a pamphlet form and the pages are smaller. Maybe you want to capture a lot of extra policies. Best places to look up state law, that really varies. Bloomberg law is a great place. Lexis has some great resources. Going to state DOL pages, I think, are great places to go as well. You kind of Google your various Department of Labor in your jurisdictions, and that's a great place to see things. You're welcome to those people who are thanking me. Testing procedures. You don't have to put testing procedures for drug testing in very significant detail, but you want to say what you're testing for, what drugs you're testing for, and some general comments about how it's going to happen. People are going to provide, let's say, urine samples in a private, confidential space. They have the ability to talk to an MRO, a medical review officer, about questions that might pop up about the drug testing process. So you want to still say some things about it. I guess that's kind of what I'll say about that question. And it looks like the last one that I'm seeing is thoughts on testing when a workers' comp injury happens in a manufacturing setting. Generally speaking, there might be a requirement, first of all, to test on your workers' comp plan. Many manufacturers have a drug testing policy that says if you are involved in an accident or a near accident, then we're going to drug test you as a matter of ruling out drugs from the incident. You still have to consider some state law issues, and it gets tricky because if you test somebody, as someone mentioned earlier, and they have marijuana in their system, was it medical marijuana, and when was it last used, and were they under the influence? They might not have been under the influence, but now you've learned information, you might have to handle it and potentially accommodate it depending on what happens. So it gets really tricky, but I think generally speaking, if you're in a manufacturing setting, I think it's very common to have testing done after workplace incidents. Okay, wow, that was really great. And oh, and I see a comment of some more thank yous, and you're welcome. Someone, Jenny just says, as someone who just tackled a multi-state handbook for a client, I understand the work it takes. Great information. Well, thank you. All right, I'll turn it back over to the team. And again, as I said from the start, I'm happy to hang around for a little bit if people want to ask me more questions. But thank you. It was great being back here again, talking about a favorite topic, and wishing you all a happy New Year.
Mark, thank you for a wonderful presentation. On behalf of Bucks County and our regional workforce development partners, thanks to everyone who joined the webinar. And please, before you go about your day, make sure that you register for our next WED Talk on December 13th. Details are available at www.buckscounty.gov/WEDTalks. Have an awesome day, everyone.
Thank you, Billy. Thank you.
Bye-bye.
Dan, thank you.
Thank you.
Thank you, everybody.